It's nice to be here this afternoon, and I think we're in for an interesting discussion. We are joined here today by Joel Sati. He's an assistant professor of law here at the University of Oregon, and his work focuses on the phenomenon of illegalization, which he defines as state practices of criminalization that use immigration enforcement as a tool of social degradation. He received his PhD from the University of California at Berkeley and his JD from Yale Law School. And we'll also be hearing from Garrett Epps, who's a professor of practice here at Oregon Law. He's also been at University of Baltimore Law School, and before that, all back here at Oregon. He served for 10 years as the Supreme Court Correspondent of The Atlantic and published more than 400 essays analyzing the Supreme Court's evolving jurisprudence and constitutional issues. He received his LL.M and J.D. from Duke and an MA from Hollins. So I think we're going to start off with Professor Sati.
So, by the way, thank you for the opportunity, and I'm really excited to talk about this. That said, I haven't spoken in front of people in like 4 months, so you'll have to forgive me. But on the surface, the Supreme Court's ruling in the birthright citizenship case, Trump v. CASA, was about the legal question, or the very dry legal question, of whether federal district courts can issue universal injunctions, that orders that constrain the government from acting against individuals beyond those who brought the lawsuit. But the impact of the court's decision is likely to be seismic, both because of the fundamental nature of the right involved and the underlying challenge, and because of what the ruling portends for future challenges to unlawful executive action. So Trump v. CASA arose out of multiple challenges to Trump's Day 1 executive order that sought to strip birthright citizenship to children whose mothers were undocumented or on temporary visas and whose fathers were not citizens or lawful residents of the United States. And the executive order was slated to take place, to go into effect on February 19th, 2025, and it would have applied to children born after that date. Membership-based organizations in various states immediately filed lawsuits in federal district courts across the country challenging the executive order as unconstitutional under the 14th Amendment to the U.S. Constitution and as a violation of section, I think it's 1401 of the Immigration and Nationality Act. Every court the courts concluded that the case is likely, that the executive order likely violated the Constitution and enjoined its enforcement, preventing Trump from taking away birthright citizenship from anyone, even people who had not sued. And so the Trump administration then saw a partial stay on those injunctions, so that's a pause, and eventually this, from federal courts of appeals and then the Supreme Court. And the Supreme Court agreed to hear the case and consolidated 3 cases, 2 filed by the states and 1 filed by CASA and the Asylum Seeker Advocacy Project on behalf of individual pregnant women and members of those organizations impacted by the executive order. Now, the court's review in the case was limited to the issue of whether it was appropriate for the district court to issue universal injunctions, or whether relief had to be confined to the plaintiffs in the lawsuits. So the case was not considering whether the executive order violates the 14th Amendment or violates the citizenship clause of the 14th Amendment or the INA in the June 2025 decision. And another interesting note about this case is that it also arose on the court's so-called shadow docket, which means it arrived at the Supreme Court at lightning speed based on preliminary injunction briefing without lower court's full consideration of the merits of the case. So now, the shadow docket is itself an object of controversy, so we can put that to one side. Now, in the decision itself, the majority opinion was authored by Amy Coney Barrett and joined by the other 5 conservative justices, held that the government was likely to succeed in their argument that the district court's injunctions likely exceeded their authority under the Judiciary Act of 1789. And the court took a deep history into the history of injunctions and the court's equitable power, stemming from the High Court of Chancery in England at the time of the founding of the U.S., finding that because, and quote, because the universal injunction lacks a historical pedigree, it falls outside the bounds of the federal court's equitable authority under the Judiciary Act. And then having decided that the universal injunctions were not legal, the court then turned to the specifics of the birthright citizenship cases. For the individuals and associations challenging that executive order, the court concluded that they could obtain quote unquote complete relief through an injunction that benefited them and their members alone. So therefore, a broader injunction in their case wasn't necessary. The court, though, admitted that the issue was a bit more complicated for the states that sued. In those cases, the states had argued that a blanket injunction against enforcement of the executive order was necessary to avoid the reality of people continuously crossing state borders, and that a patchwork injunction would be unworkable and would cause them substantial financial harms. On that issue, the courts punted to the lower courts to decide, in the first instance, whether a narrower injunction is appropriate in cases where the states sued. And in terms of what this decision means moving forward, I'll leave that to my colleague, Professor Epps. But there are some questions that are unanswered. So the first is whether there's still any way to block the executive order on a national scale. So some possibilities remain. So courts could conclude, or the lower courts could conclude, that states who challenge the executive order cannot obtain complete relief without a nationwide injunction, or any of the individuals challengers successfully converting their lawsuits to class action lawsuits, which would then cover any child born after February 19th, or who would be denied citizenship under the executive order, and then getting a court to agree to enter an injunction that protects the whole class. And so this is the tack that plaintiffs in the CASA case, in that they filed an amended complaint and motion for class certification within hours of the Supreme Court decision, and other plaintiffs quickly did the same. So, where does that leave the administration? So the administration can still develop and issue guidance about how the executive branch will implement the executive order, and so the scope of any renewed injunctions or certified classes, in addition to the merits of the underlying issue, will certainly end up back at the Supreme Court.
Okay, thank you. Professor Epps.
Thanks, Joel. I think you've done as good a job as can be done of untangling a completely incoherent proceeding in front of the Supreme Court. I have to start with a quote, one of my favorite quotes from Chief Justice Roberts, who was a lawyer in the White House counsel's office under President Reagan, and he sent President Reagan a memo pointing out that he should be happy that the Supreme Court had ended its term at the end of June because, quote, the Constitution is safe for the summer. That's not even true under his court, right? They've been chewing up the Constitution weekly all summer. So I have apprehensions about this case. I think it may be, certainly is the most important case since Heart of Atlanta Motel and the South Carolina versus Katzenbach. It may be the most important case since Dred Scott. A lot of scholars are saying, don't worry, this order is so grossly unconstitutional, this court will just slap it right down. I remember I covered the Affordable Care Act case where former Solicitor General Charles Freed said, you know, it will be 9-0 if the court doesn't find for the government on the Commerce Clause issue, I will eat my leather hat. He ate a cake baked like a hat, but so I'm very worried about what comes next. Now, we don't know when the merits will reach the court. It could be that cert will not, you know, we won't have decisions in the courts of appeals and cert will not be granted until we get to the next term. I want to make a few points about it going forward. And the first is that, to me, this is the most outlandish, screwed up case I have followed since I became Supreme Court correspondent for The Atlantic in 2010. This case is like a ball of string that, you know, you went out, you went shopping, and the ball of string was on the floor, the cat unraveled the whole thing, and then your 4-year-old daughter came along and tried to roll it back up. It's nothing but tangles, and how they're going to maneuver past it, I don't know. The first tangle is that the Trump executive order claims that it is based on the original intent or original public meaning or whatever buzz phrase you like of the Citizenship Clause. That the phrase in the Citizenship Clause, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Their claim that subject to the jurisdiction actually means having a permanent residence in the United States and not citizenship anywhere else. It doesn't mean that. That's not what it means. I have spent 20 years studying this ratification of the 14th Amendment. I have found no evidence to support that claim at all. This is an originalist claim that, like so many others, was conceived of around the turn of the 20th to 21st century by fringe groups, the Claremont Institute. Our friend John Eastman, I had a debate with Eastman in this very room, advanced this idea more or less out of the blue, and it has now moved into the center of legal discourse. And, you know, I think the merits are clear. You know, I'm not eating any hats, but, you know, there is at least a chance that the court will see that. The second tangle in the ball of string is the fact that the administration's order is a claim that the real original meaning of a 13-word clause is the following 88 words. The privilege of United States citizenship does not automatically extend to persons born in the United States, one, when that person's mother was unlawfully present in the United States and that person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, or two, when that person's presence in the United States was lawful but temporary and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth. Now, let's assume, arguendo, that there is some serious debate about the original meaning of this clause. Spoiler alert, there isn't. But assuming that there is, it cannot be that meaning. That meaning, first of all, you scour the records in 1866, 1868, since 1868 in Wong Kim versus Ark, no one was coming forward with this cockamamie definition, and it uses terms that were that did not exist in 1868. There was no such thing as a lawful permanent resident in 1868. There was no such thing, the strange provision about lawful birth mothers not giving birth to citizens is to address the supposed problem of birth tourism, but that too was not a thing in 1868. This is, you know, as we used to say where I grew up, this is as phony as a Confederate $100 bill. Another tangle. The administration says it's going to apply the criteria to babies born more than 30 days after entry of final judgment. No. You can't do that. If that's what a constitutional provision means, it applies. The administration doesn't have the power to waive it or choose to whom it applies. And I honestly think, and if you read the order carefully, you'll see it doesn't rule this out, that they will start with the babies and they will come forward to go for adult children of immigrants, including some lawful immigrants. And one reason I say that is that President Trump actually used that argument in 2016 in a challenge to the eligibility of his own Secretary of State, Marco Rubio, who was a child of legal immigrants in Florida, and the administration was lining up to sue to get him knocked off the ballot when he withdrew. So I think that, you know, President Trump would like to have control over all matters of citizenship. He might, you know, eventually you might have a situation where the government could do something completely crazy, like, I don't know, like, what would they never possibly do? Like Rosie O'Donnell, you know, they might go after somebody like that. Final and most important tangle, and this is not just my professorial crotchet, but is the subject of a very important amicus brief from 170 members of Congress filed with the Fourth Circuit. And Jennifer has the PDF, which she can make available if anybody is interested. This cannot be a case about the original public meaning of the Citizenship Clause. Why? Because the Citizenship Clause does not confer citizenship on anyone. That is conferred by 8 United States Code, Section 1401A. Now, it uses the same terms as the Constitution, but it's a statute. And the statute is to be interpreted by the understanding and intention of those who enacted it. And if you go back to 1940, when the first codification of the Nationality Act took place, 1952, when it was recodified as the Immigration and Nationality Act, the record is extensive, beginning with a presidential memo in 1940 and moving forward, that everyone involved understood the law to be that someone born in the United States, regardless of the immigration status of his or her parents, was a citizen. There were some people who said, is that a good idea? But no one who said, that's not the law. And so Congress enacted this statute with that meaning. So if you come along with John Eastman and change the meaning of the clause, it doesn't matter. Because what matters is Congress's intent. And Congress has had control over birthright citizenship since the beginning of the Republic. The first Congress in 1790 passed the Naturalization Act, which extended birthright citizenship to children of American citizens born beyond sea. And before the Civil War, after the passage of the 14th Amendment, well into the 20th century, Congress has been extending birthright citizenship by statute to people who are not clearly entitled to it by the Constitution. Residents of Puerto Rico, Native Americans, residents of Guam, residents of Panama Canal. The Citizenship Clause has no bearing whatsoever on Congress's power to extend birthright citizenship, and that is what Congress has done in Section 1401A. You know, as you may have figured out, I could go into this much more, but I won't. All right. What does this mean for the result? I think in this Congress, I mean in this court, everything is up for grabs. I don't think there's any firm doctrinal mast we can hold on to. The guns are rolling around the deck. And when I think about this court, I'm reminded of something Theodore Roosevelt said about his own appointee, Justice Oliver Wendell Holmes, Jr., because when they told Roosevelt that Holmes had voted against the government in United States versus Northern Securities, Roosevelt burst out and said, I could carve a better judge than a banana out of that. I think we could carve a better court than a banana out of this one. But it may be that cowardice on the part of the court is our hope. Because the court can decide this case on the statutory grounds. The court can say, with all due respect to the president has tremendous power in this area. He can exercise his power. His power is laid out in Article 2, Section 3, to recommend changes to the law to Congress. And if and only if Congress changes the law, spoiler alert, they're not going to, then the constitutional issue will be before us, and we will consider it. On the other hand, you know, we are seeing this court splinter, you know, case by case, and these various straddling opinions and concurrences being written. And if you were a sort of cowardly Supreme Court justice, and I don't name Justice Kavanaugh, not at all, that the statutory decision could be the basis of a, kind of Lewis Powell-like opinion that resolves the case, a 4-4 court and resolves with the 5th vote. And at any rate, it is possible for this court to decide this case without saying, no, Trump doesn't have the power, no, it's wrong, no, the conservative legal movement, the line is incorrect. They could just say, come back and bring it to us when you've got it. It may be that, what is it? You may say I'm a dreamer, but I'm not the only one. I am hoping the court will take one of these ways out without grappling with this entirely fraudulent claim about the meaning of the 14th Amendment. And I will leave it there. I want to say one more thing, though. This is entirely different. I want to say something about our moderator. I think that it's important for us here to note that people like Christine are on the front lines in a very, very dark time in our society. And I taught immigration just long enough to know it was too hard for me. And I just think that Christine and people like her are owed the thanks of people in this room who care about the law and care about making government obey the law. Thank you.
Thank you. Perhaps turning a little bit to that maybe more practical issue of like what would happen if this, if we no longer had birthright citizenship. I was wondering if, and this may be a question for Professor Sati, could you speak to the concept of statelessness and how the elimination of birthright citizenship would impact that in the United States?
Yeah, so if something like this executive order went into effect and people babies whose parents were either undocumented or here temporarily, so they really wouldn't have a place to call home. They wouldn't have a state. And it's almost kind of taken for granted that people should have a state, should have the right to call a place home. And so my research is actually on something like this. So I have, as Christine had mentioned, so my work is on this concept of illegalization, thinking about how states use immigration enforcement as a tool of social degradation. And so the idea behind either rendering people statelessness or going after revoking people's visas, revoking people's legal permanent residence, is the process of making them illegal, or this dynamic process of illegalizing them and making it such that it is more palatable to sick the dogs of immigration enforcement on these communities. And so part of that is making the claim that they do not belong, at least in America. And it's kind of that statement, I don't know where it's from, maybe you might know, Garrett, where a bartender says, you can go anywhere you like, you just can't be here.
You can't sleep here.
Yeah.
Yeah.
So, and so we're seeing what is essentially a systematic all-out assault on belonging for people who aren't white. And so there's something actually really significant about attacking babies or kind of making them, by the very fact of their existence and nothing else, illegal or just not belonging to the American story.
If I could add, I don't think they have really thought through this. There's a big body of international law about statelessness that's grown up after World War II, with all the displaced persons in Europe and so forth. And when I debated Eastman, I said, what's going to happen to these babies who are stateless? To which To which he said, I hadn't thought about that. Now, first of all, you hadn't thought about it, but secondly, it's the only time in my career that a Federalist had said something like, you know, you make a good point, I hadn't thought about that. So it was kind of ingenuous. But there is all kinds of nightmare involved in this. Because the question is, how do you decide? You know, even if we confine ourselves to the babies, how do you decide who is a citizen or isn't with a newborn baby? Mm-hmm. Well, we have an automated system now where Social Security numbers are assigned to babies at birth, and hospitals all participate in it and so forth. That's out the window because you don't assign a Social Security number to a non-citizen. And so you're going to have to demand citizenship papers from the parents who may not have them, or who in fact may be undocumented and not willing to present themselves. And you may have a situation where women are giving birth without going to the hospital because it involves immigration enforcement. And meanwhile, the states are trying to figure out who's in, you know, one of the interesting parts of their complaints in these cases is, you know, how many federal assistance programs are only available to citizens. So Head Start, for example, you can't enroll a child in Head Start who's not a U.S. citizen, et cetera. We've got an easy way to tell now. You're born here? Yeah. Subject to the jurisdiction? You bet. If we're just in unknown territory, I don't think anybody knows what's going to happen. I'm not sure the administration has thought it through.
But I think that's a great point about sort of this opening the door for government intrusion into spaces like the medical space,
Yes.
women's health care. And so these kinds of interactions between the government, those spaces, and whatever principles we take for granted about information sharing.
Yeah.
And so if someone doesn't present their information, or someone does present information and then they're further exposed, you know, to immigration enforcement, that's really significant. Actually, a bit of a shameless plug, I actually write a paper on this published a paper on this very thing at the UCLA Law Review titled Privacy and the Impossibility of Borders. So definitely check it out. I think it's good.
Well, and I think another aspect that sometimes people might think of this as being a problem for immigrants, but this would be an issue for everyone giving birth in the United States, because everyone would have to prove their citizenship in order to prove their child's citizenship. And so I think it would also be an incredible burden on, you know, poor citizens.
Yeah, we've already had cases in the Rio Grande Valley where children born to families who have been resident in what is now Texas since it was part of Mexico are being told that their children are not citizens because they can't produce birth certificates. And it was, you know, reasonably common in previous generations for women to not have a birth certificate, to have a midwife at home, not to go to a hospital. Yeah. So that's just a slight taste of what would be waiting for us if the court makes what I consider to be the wrong decision.
As a practitioner who we try to turn towards humor sometimes to make it through these dark times, and one thing we've been thinking about, so what if you have a stateless child, birthright citizenship has gone in the United States, you have a stateless child who grows up and marries a United States citizen, to adjust, to become legalized through your U.S. citizen spouse, you need a legal entry. Is that going to be a legal entry, being born in the United States? No. I'm sure they'll work it out if they
They're smart people.
We
have a little time.
We have a few minutes. Should we take questions from the audience?
Sure.
Do we have questions? Here's one up here.
Is there a reflection?
Can I have used the mic just so that
Okay, great. I get a mic. I mean, we've been here before in the 1920s. In some ways, it seems like this is a trend that we've cycled through already, and I think it took World War II to take us out of that. Any thoughts on, you know, the historical perspective of where we're going and where we are?
I think we're facing, if this case comes out the way I'm afraid it will, we are facing something a good deal worse than the 1920s. No one in the 1920s questioned the citizenship of born Americans. There was a lot of deportation, the Red Raids and Emma Goldman and so forth, and there was a lot of anti-immigrant frenzy. But I don't know of any attempt to literally wipe out the legal existence of American-born children during that period. I don't think we've seen it since slavery times, to be honest. I think that what would happen if this case comes out in favor of the administration is that we will have created a class of people who are lesser than everyone else, and whose lesser status is hereditary and lifelong. Hierarchical, hereditary, lifelong. That's a definition of slavery. And I think some of the impulse behind citizenship stripping is the idea that it would be really jolly for employers to be able to exploit people and have them not have rights. We already had a case in Mississippi during the first Trump administration, as I recall, of a gentleman who was undocumented, who owned his own home, lived there with his family, had no criminal record. The police broke into his house because they got the address wrong. They weren't there for him. He didn't know what was going on. He came running at them. They shot him dead. And when his family sued, the state of Mississippi pleaded that he had no rights because he was unlawful immigrants have no rights whatsoever, and that therefore he could not collect. Now, the court said, out of here, right? But that argument, Samuel Johnson once said, the reason by degrees succumbs to absurdity as the eye becomes accustomed to darkness. We are going to hear that argument very quickly if the case comes out the wrong way. And I think it is, I do not wish to minimize the 1920s. I think you make a very good point. But I think we are headed for something, possibly headed for something a good deal worse.
I really appreciate the questions you're raising about what would happen if, and where does that lead, and where does that lead, and where does that lead. And I really do appreciate the comment about the women giving birth. And they're in the middle of giving birth, and they haven't gotten their documents. Is that going to open the door to everyone in the US having to carry documents? And what if she can't say or prove who the father is? His documents have to be present at the same time also. Or what if it was a rapist and we don't know who that person is? Or. I wonder what your thoughts are. Am I being extreme to even think of those possible?
Not at all. Actually, the Berkeley professor Kiara Bridges does work on poor and working class women who have to access government assistance, and a lot of it is very intrusive based on the idea that they have to reveal so much not only of themselves but also of their family dynamic in order to even be eligible for government assistance. So for undocumented women, or for women who, so a lot of people, so there are 12 million undocumented people, and a lot of those exist in mixed status families. And so even for citizen women who are working class, the fear is interaction with a government agency. They could either expose information about themselves or information about their family member. And so going to your question, so what happens if they can't provide this information, or what happens if they can't? That the absence of that information would still expose those women to immigration enforcement. And so they might And so it would put really those women in a very impossible situation.
And if the father could not be proven at that moment, say it were incest, and the woman giving birth were at great risk for all sorts of reasons, for naming him, or did name the incestuous father, and he denied it, then we'd be having a court case about a criminal matter of perhaps an underage woman, and how long would that take? And meanwhile, there's this baby.
I think, I apologized when I was asked to be on this panel because I said it's a little bit like asking Captain Ahab to come and give a 10-minute talk about whales. This is something I have spent years thinking about. And one of the things, as I totter into my dotage, I'm cursed with a long memory, and what I remember is something that happened in the Bush administration, the second Bush administration. After the passage of the USA Patriot Act, which we all recall, there was this very bizarre episode a year later in which a leaked document appeared from the Justice Department. It was never established who leaked it or who wrote it, but it was Patriot Act 2. It was a law extending, it was a proposed statute extending the Patriot Act, and one of its provisions was that if the Attorney General designated a person, a citizen, as a member of a terrorist organization, that person would lose their citizenship. No court proceeding, purely administrative. And I don't think this is an ambition that, I don't know who wrote this 88-word definition, but it was some intern at Heritage. And these people have not given up that ambition. This is a dagger aimed at American citizenship generally, and moving it into the gift of a powerful government instead of the birthright of us, the people in this room.
Wow, a lot to think about. I think the vision that I've always gotten from that Trump's vision around, basically saying you don't just to be a citizen just because you're born here, is the idea that it would, that our laws would then be able to deport both mother and child, and so I can't even imagine what that would look like if, anyway, that's kind of what I'm thinking, that he thinks that this is going to be, like the easy way, and it's going to discourage future immigration, illegal immigration to, because people, I don't want to sound like, basically, it is a way to get into the United States, is to have it come in and have a child. And I don't have a problem with that. I think if that's the way you need to work to have a quality life. But anyway, I guess my question though is what do you imagine that would look like if it passed and then it was like, okay, your child is born, they'd have no citizenship, so you either have to get rid of the baby or you have to leave with it.
Well, I think it's important to understand that that's happening right now, and that undocumented mothers of American-born children are being deported, and they're given, if they're lucky, they're given the choice of leaving the child or children with relatives or taking these American citizens with her. And, I think that, the ambition of this project is quite large. One of the things is this idea that if you come to the United States illegally or in an undocumented state and have a baby, the baby is called an anchor baby, right? And that's, a wonderful piece of propaganda because it takes a baby, right? Babies are nice, they're cute, right? It turns it into a lead underwater thing that we need to get rid of. We need to cut. We need to get rid of this anchor. It actually doesn't produce instant residency for the mother. There is, it doesn't produce citizenship. The child would not even be eligible to apply for citizenship for his or her parents until they turn 21. So there is this idea that, and Trump always says, they have a baby and then, they get all kinds of benefits. I'd like to know what they are. So I think it's important to kind of think about what's really going on, what's really happening on the ground. The anchor baby thing was a stroke of genius, but it's not real.
Still need that
Got
legal entry.
one more question, maybe way over here. So you'll be the last word here.
So, if we're going to say what's really going on, what's going on is racism. And you're using some sort of legal mechanism to push forth an agenda of getting rid of those people, right? So in the, 1898 Wong Kim Ark's court case about whether or not he was a citizen. He was born in San Francisco. He was Chinese American. That was the one that kind of established this whole birthright citizenship stuff. But the only reason that one passed was because the judge was like, oh, if we say he's not a citizen, then what are we going to do with all those Scottish, Irish, and all these other folks who came over who are white? Now, we've been here before, and somebody else said that too. So we're going to be back there where it's going to be, what about the immigrants that this administration does like, who may fit a certain criteria, who may look a certain way? They're going to lose it too. And I'm not sure how well Heritage Foundation, or whoever is writing these things, has really thought these things through. But we have been here before, and we're seeing it in other areas where we see that DOJ fired too many people, or the tariffs are now screwed up, so we keep delaying. And I'm not saying that they haven't thought things through, because we all know that that 2025 project was in the works for a while. Project Esther is now like kicking in. But it's like, talk about the babies, talk about all the heart and soul and the commitment and the dedication and all the things that are going to tear families apart. They're not thinking this through thoroughly, are they?
I wish I thought that were true.
Yeah.
I think they have. Mm-hmm. And I think that you're quite right that there's a racial component to what's going on. And in the most recent case that came out of the the occupation of LA, in which the Supreme Court lifted without explaining a judge's order that said that ICE could not target people for citizenship checks just because of their race, the Supreme Court green-lighted that. I think you can see that a great deal of this is about getting rid of the large population of Latinos, and including American citizens in this country. And Laura Loomer, the president's whisperer, put a thing on social media with a picture of alligator Alcatraz, and it says 62 million alligator meals. That's how many Latinos are in the United States. That's what's being talked about.
And just to add, I think even since Trump's initial executive orders back in 2017, a lot of the enforcement is predicated on just allocations of discretion. And so at the sort of interpersonal level, it's going to be sort of on the officer's judgment as to who poses a public threat. And I think a lot of that is going to be a reflection of the rhetoric baked in that, it's Latinos, it's people of a certain race. So even if it theoretically could apply to, let's say, I don't know, Norwegians or Irish undocumented folks, but in practice, I don't think it'll look like that.
So I'm sorry we're ending on such a dour note. There's a lot more to unpack here, but I think there's obviously more we can all think about, and
work on. I don't know, Christine, if you have any one last sentence here, but I just would thank you again for this panel. I know I'm standing between everyone and a reception, but let's thank our panelists and our moderator.